So, what happens when your home starts falling apart and you and your homeowners association have a complete standoff about who's supposed to pay for it? Well, it's a battle that almost always comes down to the fine print. And this real life story, it shows you just how much every single word in a contract really, really matters. Okay, just imagine this for a second. You get a notice from your HOA. The big wooden beams on the outside of your house, yeah, they're basically rotting. The HOA says it's on you to fix them. But you look at your contract and you're pretty sure it's their job. This isn't just a what-if scenario. It's exactly the situation one homeowner found himself in. So let's meet our players. On one side, you've got Peter de Scheel, the homeowner, and on the other, the Sandpiper Scottsdale Association, his HOA. Right away, you can see the classic David versus Goliath setup, a homeowner taking on the board. And things escalated pretty quickly. It all started in August 2018 when the HOA sent him that demand. A few months later, by February, he wasn't backing down. He filed a formal legal petition, basically saying, nope, you're wrong. And just a few months after that, boom, they were in front of a judge, ready to settle it once and for all. Now, this whole entire dispute really hinges on just one thing, the community's rulebook, what's officially known as the CC&Rs. The answer to who's right and who's wrong, it's buried somewhere in all that legalese. So the homeowner's whole argument starts right here with Article 5. And on the surface, it seems pretty straightforward, right? It says the HOA is responsible for maintaining exterior building surfaces. And to him, rotting beams definitely sound like they fit that description. But of course, like with any contract, there are exceptions. The document has a list of specific things the HOA does not cover. Things like roofs, driveways, that kind of stuff. But here's the kicker. You know what's missing from that list? Any mention of architectural beams. And that single omission is what creates the entire problem. The homeowner's logic is simple. The beams are on the exception list, so they must be exterior building surfaces that the HOA has to fix. But the HOA comes back with a clever argument. They claim the beams are actually part of the roof, which is on the exception list. And that, they say, makes it the homeowner's problem. So, with two completely different interpretations of the same words, the judge had to turn to the evidence. Which side had the proof to back up their claim? The HOA's first strategy was to lean on history. Their community manager got up and testified that, hey, they'd always made homeowners pay for these beam repairs. Their argument was basically, this is just how we've always done things around here. But legally, their whole case was built on this one simple idea, which the board president also repeated in her testimony. For the HOA to win, they had to convince the judge that an architectural beam is, for all intents and purposes, the exact same thing as a roof. And this is where the whole thing just flips on its head. Because while the HOA's lawyers are busy making one argument in court, the homeowner had a piece of paper, evidence of the HOA saying something totally different, in writing, to the entire neighborhood. And there it is, the smoking gun. On the left, you have their legal argument in court. Beams are part of the roof. But on the right, a quote from a newsletter sent out by the HOA's own president. And look what it says. It lists roofs and architectural beams as two completely separate items that homeowners need to maintain. In their own words, they had completely torpedoed their own legal defense. Okay, with a piece of evidence like that on the table, the judge was ready to make a call. So let's break down the legal thinking that finally settled this thing. So to really get the judge's decision, you have to understand the legal standard here. It's not like in a criminal case, beyond a reasonable doubt. It's called preponderance of the evidence. The easiest way to think about it is like a scale. The homeowner just had to pile on enough evidence to make the scales tip even just a tiny bit in his favor. That's it. And here are the judge's own words, which are just perfect. The judge points right to that newsletter, saying the HOA itself specifically distinguished roofs from architectural beams. Because of what they wrote, the HOA completely failed to prove their main point. So the verdict was crystal clear. The judge ruled for the homeowner, Peter de Scheel. The HOA had violated its own contract. They tried to make him pay for a repair that was, according to the rules, their job all along. And it wasn't just a moral victory. The judge ordered the HOA to pay Mr. de Scheel back the $500 it cost him just to file the case in the first place. So, okay, this is one specific story from one neighborhood in Arizona. But what are the bigger lessons here for anyone out there who lives under an HOA? Well, the takeaways are actually huge. First and foremost, the exact words in your HOA documents are everything. And when those words are a little fuzzy or ambiguous, the winner is usually the person who has the better evidence. And as we just saw, that evidence can be something as simple as an old newsletter. At the end of the day, your absolute best protection is to actually read your documents. And don't just skim them, read them, understand them, and know where the fuzzy parts are, because that's where these fights always begin. Which kind of leaves us with one last question for you. You live by a contract, just like this one, a set of rules that governs what's probably your single biggest investment. So the question is, have you really read it? Do you actually know what it says?